Good morning. You're Raul Carreno, and Mr. Carreno's case is set for trial to begin with jury selection next week. Mr. Matuska, Mr. Nichols did mention to me this morning an issue.
It's with scheduling. The DNA was sent out to a private lab, and they were requesting a little more like a month or so ahead of time notice, and I only gave them a few weeks, and they said they wouldn't be able to schedule.
Okay.
So I'm asking for a reset for that.
And that's a private, it's not the normal lab that we use?
It's not DPS, it's a private lab that was used to expedite testing in this case.
Okay. Obviously, we need that, I would think. Okay, so what I'm going to do is I'll reset it to the next trial docket. Obviously, at that point, it'll be time probably to get it done. That'll give you plenty of time to get with them now that we know that issue. And so we'll get that taken care of and get it on the next trial docket.
Yes, ma'am.
Okay, thank you. Go back with the bailiff.
Buckle up, guys. Today we're going inside a real courtroom where every second carries weight. The judge steps in, calm but commanding, setting the tone as she opens the day's docket. No theatrics here, just quiet authority as she reviews cases, resetting trials and controlling the room. You can already feel that tension rising, even before the first case begins.
Is Mr. Samuel here? Oddone Samuel?
I did see.
Oh. Yes, I'll hold your case. And Mr. Wilkerson, it looks like you've got a tablet out. Are you working on paperwork on Mr. Johnson?
No, Your Honor.
Okay, Romeo Johnson. Morning.
Morning.
Morning. Good morning. Are you Romeo Johnson?
Yes, ma'am.
And this is cause numbers 24 DCCR 2095 and 2419. Mr. Johnson's cases are set for trial to begin with jury selection next Monday. What is the announcement?
We're ready, Your Honor.
All right. Anything that change in negotiations that we need to go over today?
I was given some additional discovery materials, but it's just a complete autopsy.
Okay.
There's no new offer or anything for me to present to my client.
I'll entertain a counteroffer.
All right. If y'all want to visit this morning, just to double check if there's any counteroffer or anything like that, let me know. I'll hold it for a minute. Otherwise, it'll get numbered for trial.
Yes, Your Honor.
Okay. Thanks.
From there, the next case rolls in. Romeo Johnson. The judge quickly dives into the details, confirming trial readiness and new autopsy evidence. The atmosphere shifts. The defendant stands still, eyes forward, while the courtroom grows tense. This isn't just paperwork anymore. The sense of gravity starts creeping in, hinting at the bigger conflicts still to come.
Mr. Galmore, you've got Ronnie Green.
Good morning.
Good morning. Good. How are you?
Pretty good.
Let's see here. And this is for, you're requesting bonds on the two motion cases,
Yes.
correct?
He's on deferred on two different cases.
There's also additional.
Thank you. I'll pull that up now, Mr.
I'm just really asking for a setting on those additional files.
Okay. Oh, okay. Okay. Good morning. Are you Ronnie Green the third? And Mr. Green, we have 23 DCCR 1502 and 24 DCCR 1320. Mr. Green is on probation for possession of a prohibited weapon and possession of marijuana. Motion to revoke probations have been filed in those two cases. There's a new indictment in cause number 25 DCCR 0735
Now we meet Ronnie Green III facing a complex legal battle. The judge goes over his probation and new charges while setting up his bond hearing. There's a sense of measured caution in her tone, every word carefully chosen. Green nods, but you can see the unease. The calm before confrontation fills the air as his defense prepares to speak.
Mr. Green is charged with money laundering. Mr. Galmore has filed writs asking that I set bonds in those 2 MTRP cases. He is on deferred probation, so generally entitled to a bond, but based on the nature of those offenses and that new offense, I wanted to have a hearing and get the state's input on their position on bond amounts, and bond conditions.
Your Honor, the state's filed a reply to the writ that was filed by Mr. Gilmore. I don't know if you had an opportunity to see that. I've kind of laid out the state's argument
Okay,
in that reply.
let me look at it
I'm happy
real
to read
quick.
that.
I feel like I might have seen it, but I've slept since then, so give me a second to.
Judge, I don't know if you see letters in there as well. There's been letters that have been supplied to the court.
Okay, I'll take a look at all of that. I don't know. Do I have any of that over there? Anything printed out on him? Some of that sounded familiar. Yes, okay, so I saw the letters.
Yeah.
I can summarize this for you, Judge.
Okay, the letters I got. Brandon, let me look at this real quick. Now this is looking familiar as well. Oh yeah. And I recall now what you filed also with regard to some requests, and we'll get that set for.
Here the judge references letters submitted to the court, a small but intense moment. She reads through them, the courtroom silent, her eyes scanning every word. You can feel the anticipation building. What's in those letters? What do they reveal? It's the kind of pause where no one dares move, waiting for her judgment to fall.
The appropriate time, Mr. Coleman, as far as modifying bond conditions and things like that. And I guess you've seen those.
Absolutely.
I don't know if y'all want to talk about that, if there's some agreement or not. But for this morning, Mr. Galmore, I guess you can just make argument or.
Yes, Judge. I would just like to summarize a few things real quick. He is on probation for 2 cases. They are different offense dates, but I want to point out that he did not receive probation and then pick up a new case. These were the situation where he received probation and there was an older case that just simply not been filed yet. Since he's been on probation, there has not been the commission of any new offenses other than the offenses we're talking about today. I will say that he's been in jail for 20 days, which is longer than any other time that he's ever been arrested before. I did have discussions with the state today about a possible resolution that would involve Mr. Green going to ISF and not revoking his probation. And that sounds like a reasonable outcome. I have not had an opportunity to review the discovery in the new case, and so I don't feel like I'm in a position yet to advise my client on what would be the best option as far as that's concerned. I would point out that in the letters, there's one thing that really kind of struck a chord with me, is that since this alleged offense of the money laundering, which was earlier this year, Mr. Green has really taken a lot of efforts in his life to start walking the correct path. He became more involved in his church. He was baptized since the alleged commission of this offense. He's got a lot of family support. His mother is here in court today on his behalf. And so what we're just simply asking the court to do is set reasonable bonds. He is on deferred. And even though there is a new offense, I would say that the majority of all motions to revoke probations are based on illegal activity. Even if it's not a new offense that was committed, it's alleged. Very common is a failed drug test, and obviously if you're failing a drug test, you're committing a crime at some point, possessing that illegal drug. And so We're just simply asking the court to set reasonable bonds. I believe reasonable bonds in this scenario would be about $10,000 on each case.
This is where emotions spill over. Green's attorney steps forward, speaking with conviction, pleading for leniency, emphasizing his client's growth, even his baptism. It's heartfelt and persuasive, a rare human moment in the rigid world of legal talk. The courtroom energy shifts, and for a second, it feels like redemption might actually be possible.
I believe the government is asking for $50,000 in their motion.
Your Honor, and Mr. Galmer and I agreed that we were both asking the court to set reasonable bonds. My version of what's reasonable, given the fact that less than 1 year since the defendant was placed on 2 deferred adjudications, he's out allegedly committing money laundering. If the allegations are proven true that money laundering, those proceeds constitute proceeds from drug trafficking or delivering controlled substances, Judge, the opportunity, as Mr. Galmo put it, to walk the right path, the correct path, came back in 2024 when this court put him on probation for possessing a weapon that was outfitted with a Glock switch. My version of what a reasonable bond should be in light of this defendant's actions is no less than $50,000 in each case.
Calm, precise, and coldly factual, they remind the court of the seriousness and recency of Green's offenses. The emotional plea collides with hard law. It's the perfect courtroom standoff, sympathy versus accountability, and the tension is unmistakable.
So if there is two things with regard to what you're talking about. One is, depending on whether or not the allegations were proven true, and if there was some thought of continuing Mr. Green on his probations and getting a probation on that new case, the only way I would go along with something like that would be for ISF, some type of cognitive program in custody. And while I understand and appreciate that he's making some strides on his own, from a legal standpoint, it doesn't make a whole lot of sense for him to be back out and then go right back in to ISF. The point of ISF is to get that done so that when you get out, you've got better tools to make better decisions so that you don't end up in prison for, I mean, you're looking at prison up to 10 years on those 2 cases, and then you've got the new money laundering case. So
The judge takes over again, weighing both sides. She questions whether correctional programs like ISF truly work for repeat offenders. Her tone sharpens, not out of anger, but experience. She's not just ruling on a bond, she's evaluating the system itself. The audience sees her judicial reasoning unfold like a chess game, piece by piece.
To address that just real quick, Judge, the money laundering case, I've only been on the case for approximately 2 weeks.
right.
In speaking with Mr. Green, he states that he does have proof for a lot of the money, so I don't think at this point I can even advise him that agreeing to a deal where he goes ISF when that's the only violation is the appropriate route. Of course, with him being in jail, it's a lot harder for him to assist in his own defense of that case.
And Judge, of course, the state has a different position on the proceeds or where those funds were derived from and our ability to prove where they came.
Defense fires back with one last effort, insisting the money in question came from legitimate work, not crime. It's a brief but crucial exchange, the kind where truth hangs on the smallest detail. You can sense the frustration in their voice, a mix of desperation and hope as they try to pull credibility back from the edge.
Let me look at something real quick. I guess I'm just taking a look at the probable cause affidavit on the money laundering just to get an idea of what those facts are. I think I have a little bit of them from the facts, obviously, from Mr. Coleman's response to your request, but let me look at this real quick. Actually, I can't read it. I'm printing something. Maybe.
Maybe.
It's a long way. It's a long way for it to go from here to there. Okay. How long? Obviously, you need some time, Mr. Galmore, but how quickly could you get up to speed on the money laundering?
It wouldn't take me very long to get up to speed on the discovery and watching the videos, but it'd be substantially more difficult to try to track down financial records for Mr. Green while he's incarcerated in the Jefferson County Jail, which is one of the reasons why we're asking for bonds, so they can assist in that part of his defense.
Your Honor, I would offer this. When interviewed by the law enforcement, the defendant indicated that he had no records that would show the source of the proceeds they received.
That you're correct. That's what I see as well, other than maybe one social media post on Instagram.
It appears on the roadside discussions about the sources of money that Mr. Green did not have a lot of answers necessarily, but I would say that on the side of the road, the question about
Well, I think they brought him in and Mirandized him, right? Once at the jail, read Miranda warnings, waived his rights, and during the interview, couldn't explain how he obtained it, advised he sold one French bulldog late last year for $1,500, but nothing else. Didn't have a job. One Cash App thing he could show for that one dog. So
I haven't seen that video yet. I'm assuming this video recording is supposed to
it should be, yeah.
I just haven't had an opportunity to review that video. I do know that there was a car wreck where he received a settlement from that car wreck, so there were some additional funds that weren't discussed. But again, I don't have access to those records as of yet.
Now the courtroom falls silent as the judge studies the affidavit. No one interrupts. Papers rustle softly, the air thick with tension. It's a cinematic pause, where the weight of real justice fills the space. You can almost hear every breath in the room as everyone waits for her to look up and speak.